All right, so we're talking about why is mental health an ethics issue? And Tim and I are going to go back and forth about this. We're going to talk about why this is important, the kinds of challenges we have in the legal profession with mental health and substance use and stress. And we're going to talk about ethical considerations regarding. So welcome to Why is Mental Health an Ethics Issue? We're glad to be here with you today. And we're going to talk about why this is urgent, what our issues are, ethical considerations for both us and our clients, although I know that when Tim and I have done this program before, we say, and you should be concerned about your clients, and there's some slides you can look at, and he'll have a couple of things to say. And of course, we want you to know what kind of help is available. So I always like to start out with kind of making sure that people understand who LCL is and that we're available for you. We're a confidential organization that helps lawyers, judges, law students, and immediate family members on any issue that causes stress or distress. We do programs like this one. We will guide and coach people who are concerned about others and organizations who would like to either put some practices, some best practices in place, or who have a situation they would like to deal with. And we have a 24-hour hotline. We have free counseling. We will refer to other services. We have support groups. We have peer support, and we have staff members who will work with you through everything that you might be going through as you look for the best resources. So, Tim, let's start out with this great report that came out called The Path to Lawyer Wellbeing, Practical Recommendations for Positive Change. It was issued by the National Task Force on Lawyer Wellbeing with the idea that they wanted to create a movement to change what they called the toxicity of the legal profession and move toward a healthier profession, because we are dealing with so many traumatic issues. And guess what? It had a very significant ethical component. Reasons for doing this were that organizations would be more successful, and so would the lawyers within them, but that it's an ethics issue. So how does that speak to you?
It speaks loud and clear to me. Many of the matters where we see lawyers running afoul of the rules often involve someone who is experiencing less than optimal well-being. They may be suffering from a chronic condition, or it might be more of an acute issue they're dealing with that is causing them some sort of stress or distress, whether it's depression, whether it's a substance use disorder, whatever it might be, that is affecting performance. And these things can affect any of us. I think it's easy sometimes to say, oh, that's not me. But when we're even just highly stressed for some reason, we may not be at our best. And what we look at oftentimes in connection with this are the rules involving competence, Rule 1.1, which says that we need to act with the requisite level of thoroughness and the like in representing a client, preparation, etc., but also the diligence rule. And this is where we often see it. People who are not optimal, who don't have the well-being they ought to have, aren't able to tend to the things with the diligence they need. And it's easy to put something on the back burner today and tomorrow and this week, and then all of a sudden a substantial amount of time has gone by. And sometimes, worst case scenario, deadlines, maybe ones that are irrevocable, like statutes of limitations, have been missed. And what the report really deals with is these kinds of things, but also that we, not only as practicing lawyers, but those of us in supervisory capacities, whether corporate, government, private firm, have an obligation to those that we supervise to help promote their well-being, to help ensure they are acting in conformity with the rules. And the third reason, quite frankly, Joan, is to me, it's not ethics-based, but it's the most important reason, the humanitarian reason.
Right, it's the right thing to do because of the range of mental health issues that are present in our profession, not only among the lawyers, and we'll give you a few stats, not too many, shortly, but also that so many of the issues that lawyers are dealing with have a mental health component. And so these are the reasons that the task force identified. So let's talk about what well-being looks like. We've got a slide up here that's got 6 colorful circles. And up on top, we've got occupational and intellectual. Well, you know, we're lawyers and we think that the fact that we think and the fact that we're smart and the fact that we're in the top 5% or less of IQs in the nation and all of that kind of stuff, that's really important. And so we value that above the other aspects of well-being, which are just as critical to being able to have a satisfying professional and personal life. And those are emotional, social, physical, and spiritual, and I would also add cultural. But if you look at this diagram, you'll see that the job-related functions are up on top, and everything else is there to support it. And so you can think of it as a hammock, you can think of it as a boat, you can think of it as something that is there to support us in doing our best thinking. Because if we aren't taking care of these other things, we're not going to be able to do our best thinking. And it's not having that best thinking, which is what lands things in your office, right, Tim?
Yes, it is, whether it's competence or something else in terms of not best thinking, poor decision making, whatever it might be.
Mm-hmm. And so we also want to look at some of the particular sources of stress we have. We've got a list here: perfectionism, pessimism, isolation, uncertainty, and secondary or vicarious trauma. And I think every single one of these has an ethical component. For one thing, perfectionism can keep us from doing something in a timely manner because we haven't created the most perfect document ever. And so that becomes neglect and non-communication because we feel like we really haven't done everything we possibly can. And that ties in with the uncertainty. And that ties in with isolation because we may not feel comfortable asking other people for some guidance because we do it ourselves. And we also tend toward pessimism, which is that we look for the worst that could happen. Research shows that people who tend toward pessimism get better grades in law school. In every other graduate program, the optimists get better grades. But because the law school exam question or the bar exam question says, here's a fact situation, what is anything that could possibly go wrong? And so we look for that. And because we are thinking there's one more rock to turn over, we may not do things in as timely a manner as we might have. And therefore, the client gets harmed because sometimes, excellence is good enough. Perfection is really not necessary. In fact, most of the time, that's the case. And then secondary and vicarious trauma can have an impact on how we react to situations. And that may also lead to not handling something because it affects us too much, either because of something that happened in our lives earlier on that is triggered, or because it's an accumulation. Do these tie in with some of the things you see, Tim?
Absolutely, for the reasons you spoke about, and vicarious trauma, simply to pick that out as an example. I think that is something that is finally getting more recognition in the profession. The obvious examples are people who are prosecutors or criminal defense lawyers dealing with some of the horrific crimes that they are dealing with from either side and having to deal with the evidence that's involved in those kinds of cases. But there are other lawyers as well, people who are consistently dealing, for example, with vulnerable adults who've been exploited, people who do CHIPS cases. You're dealing with traumatic situations, and although it may not be to you, and it may not affect you specifically in this case, that can build and it can negatively affect your best thinking and your productivity across a number of matters. And as Joan said, then we start to see problems of neglect or non-communication or other issues involving the rules of professional conduct. These kinds of things can lead us to not doing our best thinking and to violations of the rules. And that's where well-being and ethics intersect.
Right. And there are these obvious practice areas, criminal law, family law. But when you are working with a business and you have a client who is feeling like everything they've worked for is at risk, that can be extremely traumatic. And it's not about the facts often as much as the emotions of the people you're dealing with. So if your client is overly anxious about a situation, more so than you would believe would be reasonable, that level of anxiety is still going to be what you feel, not what the underlying facts are. And so it can be in so many different practice areas. And
you will be spending extra emotional energy of your own trying to deal with that client's anxiety, trying to reassure the client, trying to help them out, depleting your resources a bit.
And one of the things we'll mention later on, probably pretty briefly, is the client with diminished capacity. That's going to take a lot of mental and emotional energy from the lawyer as well.
Absolutely.
So the well-being report also offered this diagram, this little scales of justice here. And I think this really effectively illustrates sort of the way we look at these issues in our profession. On the one side, we have a list of challenges, and these are all of the things where we have statistics. We do this too much. We have this too much. And we have all of these things that are exceedingly important. We have a higher suicide rate than average. We don't sleep enough. We don't get help. But what's happening with this well-being movement is that instead of looking at the challenges, why don't we look at the potential? And so one of the ways we deal with our stress is to drink too much. But if we were to say, okay, what is it that I would like to really achieve in my life? I would like to be healthier. And so you look at that and you say, well, how much of a role does alcohol play in that? Maybe I should do less. Maybe I should do none. And so we're looking at the potential of being strong and healthy as opposed to, oh, we have these challenges in the profession. And they're both equally critical, but I think that as natural born pessimists or as people who developed into effective pessimists, we sometimes don't look at the potential nearly as much as we can look at the challenges. So instead of job satisfaction and attrition way at the bottom of the list, we've got experiencing a sense of meaning and purpose because we've had a chance to make a difference in the life of a client simply by being present for them. And that we aren't responsible for the result, but we are responsible for how we treat them. And so those are some of the ways that we can look at this well-being, these well-being concepts and tie them into what does it mean to be an ethical lawyer? Because it's not just the rules. It's more than that, and that's what the introduction to the rules talks about, which is the, or maybe it's called a preamble, you tell me, Tim. But, you know, it's an overall thing, and I don't know how often people actually read that because it's more than, here are the technical requirements.
It is. I mean, in the end, we are a profession, and part of being a profession that has, as it shows on the left-hand side here, challenges, but it really is focusing on our potential, how we can optimize ourselves to not only make ourselves well, but also to, as Joan said, do our best thinking and really best serve our clients by having all those factors, you know, including not only the intellect, but also the boat or the hammock that we looked at earlier, to allow ourselves to be well, to have the well-being necessary to more effectively represent clients.
Right. So we do have stress in our profession. We're going to have it because we're dealing with really important issues for people who are struggling and distressed. And so that is going to have an impact on us. Anybody who's in a helping profession is going to have these kinds of stresses. But if we're not doing things to look at our resilience, build our resilience, look at our stress, find ways to manage it, find ways to take breaks, all of those kinds of things that keep it from hitting us so hard, we're not going to be as effective. We're going to have more health problems. There are certain cancers that after natural disasters go way up. The rates go way up because of what those people have been exposed to. So there's definitely a mind-body connection there. And then in our profession, we drink more as a way to cope.
Not that we should, but we do.
We do. It's one of the things we do. And as a result, we have a problem, and I'll talk about that in a minute. But before that, I want to just touch on this rule about diligence. You mentioned it earlier, Tim. Here's the rule. A lawyer shall act with reasonable diligence and promptness in representing a client. Of course, we know that the rules govern and the comments guide, but take a look at this comment to the rule on diligence. What does this say? This is permission to do, you know, healthy life choices in terms of supporting our best work, don't you think?
Yes, to be able to go to, if you're a sole practitioner, someone who walks in the door and to say, I just don't have the time, or to go to your supervisor and say, look, I know we're busy, but at some point it's too much and we need to figure out how this can be done so that I can handle each matter with the requisite diligence and competence it requires.
And what about withdrawal? That is something that people often say, well, I can't get out of the case. And of course, there are some restrictions on that, but are you required to continue to represent a client if it's having an impact on you that makes you feel like you can't do a good job?
You're not married to a client forever. And under the rules, you can and should withdraw, frankly, if, again, sometimes we're subject to court approval in certain litigation matters, but if it's to the point where your physical or mental or whatever condition is such that you cannot represent the client competently, you actually have a duty to withdraw at that point. Because you can't help the client, you can't represent them competently, and you need to stop trying to do so.
And if you've got a client who's a bully, you could say, I think it's time for you to find another lawyer. If you have a client who has a personality disorder, and I believe our materials have a resource list. If not, email help@mnlcl.org and I'll send it to you. But there's a resource list that includes an article about, does your client make you crazy? Now, I'm not crazy about the title, but it's about clients with personality disorders and kind of what that's like and how you can communicate with that client. But sometimes it's like, no, I'm not going to take this. I'm not going to do this anymore. And that workload doesn't just have to be the number of matters. It can have the it can be the emotional impact that it has on you.
Precisely. And in some cases, yes, withdrawal is really where you need to go. In other cases, it's boundary setting. Right. And we get calls about that through our advisory opinion service. I have a client who's a bully. I have a client who calls 9 times a day, emails 10 times a day, and drops in unannounced once a week. Do I really have to drop everything every time? And in 99% of matters, the answer is no. What's reasonable? And setting appropriate boundaries with clients can, much of the time, go a long way toward helping resolve the situation. There's a mutual understanding, can help control your stress, and your workload. Sometimes that doesn't work, and then you have to consider going to the next level about whether to withdraw, but sometimes just effective boundary setting and then holding to those boundaries, because that's an equally important component, can go a long way toward helping you represent that client better and to feel less stress and less angst about that client and their case.
We've talked with a number of lawyers over the years who, when the very idea of saying I'm done to a client hadn't occurred to them. And it's like, we can't advise you on what limitations there might be on that, whether you need to get permission, et cetera, but have you considered that as an option? And sometimes it means it's going to mean refunding some money to the client, but what's your well-being worth versus that money, which in the long run, you're probably spending way more time thinking about how difficult this is than what it is. And sometimes saying, I'm not sure I can continue as your counsel, changes behavior.
Absolutely. Sometimes that boundary setting or that implied warning to the client or whatever it might be can scare people straight once in a while.
Well, and another piece here too is, this is an anecdote from several years ago. The current director, Director Humiston's predecessor, Director Cole, was actually a law school classmate of mine, and we would present together, and I'd present in his classes at law school when he taught at the law school. And one of the things we would talk about is that, and this was his anecdote, that you can, if you've got a client who is pushing you on something, it's okay to call for an advisory opinion on something you very well know the answer to. But you get that advisory opinion, you can go back to your client, and these are Marty's words, Mom said I can't. And so you can go to your client and say, no, I checked it out, just to see what you want me to do, and I'm not allowed to do it. So the idea that you even checked it out, if you want to keep the client, is something that can help with that relationship. So anything else you want to say about this?
Nope.
Okay. All right. Well, I'm going to run through some data just to kind of give some background. When we talk about alcohol use, and by the way, thanks, Tim, for saying substance use disorder, because substance abuse, which we often hear, it's probably the only illness where we use a shaming term like that. The Diagnostic and Statistical Manual of the American Psychiatric Association, DSM, version 4, still called it substance abuse, and the DSM-5 calls it substance use. So it's something you have, not something you are. So think about that in language with your clients as well in terms of judging. But there was a survey that was released in 2016 that said that 20.6% of us met criteria according to what the doctors define as an issue of having alcohol use disorder. Now, that doesn't mean we have to stop. It means that we're drinking in unhealthy ways. We're using it to manage our stress. When you look at people who have gone far enough that really abstinence is a better answer, these are some of the things you're going to see. First of all, it's an illness that manifests itself in every part of us. It's primary, so it's not something that, well, you've got this and then you've got this. It will continue to get worse. You will always have it. And it's marked by increased tolerance. In other words, the longer it is, the more you can put away and theoretically not have an impact, although of course inside it's tearing you apart. Loss of control once you start. So 1 is too many and 100 is not enough. And thinking about it, and this is where it becomes an ethical issue, thinking about it to the detriment of what else you should be doing.
Yeah, it interferes. And I know someone who was clearly addicted, to use the term on the slide here, didn't drink Monday through Friday, but come 4 o'clock Friday, began and didn't stop all weekend till noon Sunday. And for years fooled himself into thinking it wasn't affecting me because I wasn't drinking during the week and I wasn't drinking on a work night. It was, and after he got treatment, he saw just how much it had affected his life, not only personally physically and with relationships, but professionally too. It does affect every aspect of a person.
And a lot of times the denial will be where we'll draw that line in the sand. And the reason it's in the sand is because it moves. But it's like, okay, I never missed court and I never had a complaint. That was what I was knocking on there. But are you bringing your A game? And so there's these little things that slip. As people develop problems, and so here we have another term that is used sometimes, dependency. So in other words, how connected are you to that need for alcohol? So, let's think about this. What does alcohol do? It reduces stress. That's fine. For a lot of times and a lot of people, that's just fine. But if you find that you're having difficulty managing your stress without it, then it starts to be an issue. If I sure need a drink is something you really feel like you really do need a drink instead of something you just say, maybe it's an issue. And early on, when you're starting to develop some habits and some behaviors, a lot of times people might have a consequence. It might be a first DWI. It might be something they said under the influence. And it's like, wait a minute, that is not how I want to live my life. And they change it. They either abstain or change their drinking habits if they can. When we get to the middle stages, I've got one hidden in there that says job impact. And what that means is that, if we're looking back at that yellow and orange circle, our intellectual and our occupational well-being, all that other stuff that we don't think is as important, even though it's all the support, that may have kind of deteriorated. But we think that as long as we're still doing our job, we're okay, just like you said earlier. And so by the time it starts to really show up on the job, we're pretty far along. And so we use despite harmful consequences. And then later on, there can be very serious consequences, and yet people can come back from late stage. And maybe you've had some cases like that where because, we'll talk about mitigation a little bit later, but because of that, somebody was able to return to doing whatever it is they wanted to do with their careers. We've got a whole list here of things besides alcohol. It's primarily alcohol, but we do use other drugs. The most commonly misused drug by lawyers, as you might imagine, is prescription opiates. And I think with greater awareness, we may see less of that. But the person with back pain never intended to become addicted, and yet that's what happened. And then we have a list of compulsive behaviors, and we don't see too many of these. They're out there, and occasionally there will be an ethical impact. There have been some cases where clearly there was a compulsive behavior that was related to the person having ethical problems. Now, I want to separate commission of a crime from having a compulsive behavior, because you can have a substance use disorder and never get caught with a DWI or never drive when you're under the influence, okay? So it's one thing to have the consequence. You can have a gambling problem, but if you touch your client's money, it doesn't matter. how bad that problem is because you touched your client's money. And so you're going to have the consequence related to that.
Yeah, there is a clear distinction between the conduct and what might be a contributing factor. But the contributing factor is just that. And it doesn't mean that you haven't, as Joan said, committed a crime or committed a violation of the rules.
Mm-hmm. And so that's really something important to remember because, and we're going to talk about mitigation later where this will all come into place, but I'll use shoplifting addiction as an example. There was a lawyer who was convicted of shoplifting. And by the time it became an ethical issue, they were getting help. And in fact, the court opinion said, well, yeah, they did this. It never harmed a client. They have a diagnosis of having a disorder that is being treated. And when you talk about mitigation, that will fit in. But a lot of these issues have been in ethics opinions. Eating disorders, I don't remember one of those, and I don't remember a compulsive shopping, but certainly all of the others have.
I would agree with that.
Yeah. And some of this is because you are doing other things instead of what you should be doing because of that desire and compulsion. And sometimes in the case of things like gambling addiction or substances that are stimulants as opposed to depressants, so like cocaine, it's about the action, and that's where there can be an issue. Rose on the screen that is disappearing. Okay.
And then we also had an email pop up.
Yep, but it's gone. So let's move to other mental health issues. Did you want to say anything else about substance use before we move on?
Like you said, I think we'll talk more about it in the context of mitigation or the effect as to a disciplinary sanction.
All right. One thing I will note about it is that when I was in law school, the person who was then the director said that they thought that half of the cases that came in had a substance use related component. And I asked one of your colleagues several years ago when I was talking in his class at one of the law schools what he thought it was today. And he said, I would say it's probably still at least a third.
That would not surprise me.
Yeah. And they aren't necessarily brought up by people. But the point is, it may not be you, but it will affect you because it might be the lawyer on the other side, the lawyer down the hall whose business you have to pay attention to, the judge, all kinds of ways in which this is going to be present. So the fact that you personally may not have a drinking problem doesn't mean that you aren't going to be affected by drinking in our profession.
Or it may be a partner or a colleague in the workplace.
Right. That's right. And that can take up an awful lot of organizational energy. That goes back to that first reason for looking at well-being. So let's look at other mental health issues. According to a Johns Hopkins study that was done over 20 years ago, we're 3.5 times as likely to experience depression as the rest of the population. And women report it more often, but there's 2 reasons for that. Maybe more, but 2 that I'm going to talk about. One is that women's depression tends to show up a little bit more as sadness, whereas men's depression can be coupled more often than women, might be coupled with anxiety and also appear as anger. And so all of the advertising about depression shows people with their heads in their hands. It doesn't show people pissed off. Can I say that? I just did. And so men get help later. The other thing is that women might be misdiagnosed because one of the things that can look like depression is anemia, and that's much more common in women. Sleep disorders can look like depression. That happens with men and women. And by the way, women get help later for substance use because they tend to be more private, so people don't see them using it as much. In the 2016 study I mentioned earlier, this is one that was done by the American Bar Association Commission on Lawyer Assistance Programs and the Hazelden Betty Ford Foundation. 28% of those who were surveyed met criteria for a depressive disorder, mild, moderate, or severe. 18% for mild, moderate, or severe anxiety at some point during their careers. 23% for stress at a level that was debilitating at some point. And this is one of the things that really surprised us working in this area is that 11.5%, when asked the question, have you ever considered suicide, said yes. And that's something that we really need to think about, because we have lost lawyers in our profession. And is it that bad? Is it that stressful that the idea of asking for help is more of a failure than taking one's life? And that's what this perfectionism, that's where that can take us. And certainly that's something that I think has affected people in your office, Tim, because being subject to discipline is something that has sometimes resulted in someone deciding that it's bad enough that that's the choice they make. And that's got to be incredibly difficult to be doing your job, and this is what happens.
It is, and it gets back to the issue of vicarious trauma we talked about earlier, but it also gets to when we're dealing with people, more often the lawyer who's the subject of a complaint, but sometimes the person who filed the complaint. One of the things that we are doing is attempting, when we meet with people, is to assess, one of the things we try to do is to assess. Now, I'm not a psychologist, I'm not a doctor, I'm a history major and a lawyer, so I have.
Me too. I didn't know that.
Yes.
Okay, back to the topic.
So I have absolutely no specialized training, but nevertheless, trying to look out for things that I've learned from Joan and LCL and others. Is this person someone that I need to be worried about? And there are times that we do take action. We might call LCL right then, or we might have this person get in contact with a family member, because dealing with a professional responsibility complaint is incredibly stressful. And some people, it can be enough to cause severe depression or thoughts of suicide in conjunction with whatever else they might have going on in their life.
And I know you get calls from lawyers who are concerned about suicidal clients.
We do, and what to do. And we do have a slide on this later, but often it's the question comes down to, I have a client who I believe is about to hurt themselves or try to kill themselves. But that's privilege, and I can't say anything, can I? And the answer to that is you can take steps to take action to protect a client who is in danger of harming themselves or others, whether it's suicidal or homicidal, because sometimes in particularly domestic situations that can happen too. And yes, you can take steps. You can disclose that information to persons who can take action to help save a life.
Mm-hmm. And it's always, always act first on what you think will make that difference. Because if you are doing the next right thing to try and save a life, I think that you don't have a lot to worry about in terms of your license.
It's most of the time it's pretty hard to second guess that decision, nor do we want to. Right.
So I've got a slide on suicide that shows that we have higher rates of suicide based on studies for many years. And women use methods that can be interrupted more often, whereas men use methods like guns. And I've got succeed up here because I want to talk about that word. That's why I have some of these words in here. That's why I think I still have substance abuse somewhere, because I want to talk about language. They die by suicide or they commit suicide. It is never successful. And so some of the things you might see is that someone is talking about worthlessness, or feeling trapped, or there's no way out, or I'm never going to be able to do anything else. And tying up loose ends. For lawyers, that might be the case that has been dogging you for years, where you deal with it. Anytime there's hints, and LCL can coach people on how to assess, and we would connect you with a counselor immediately if you're concerned about someone, to talk through what you are seeing and what you're hearing and what you might do. It's never your fault if someone dies by suicide, but you may be able to do something that will interrupt and get them in a different direction. And so there's a lot of places where there's help with that. So I want to go back to a slide, another slide, just talking about other mental health issues. All of these are things that LCL has helped with. All of these are things that we are dealing with in our profession. And grief is not a mental illness, but it's a mental health issue because somehow we think we're supposed to snap out of it more quickly. Sometimes post-traumatic stress can rise to the level of a disorder. And as our profession ages, as the baby boomers are in full-blown retirement age and getting there, we're going to have more and more instances of it's time for somebody to retire. And that's a mental health issue too. And in fact, part of the well-being report, we're not going to, this isn't today's topic, but references are listed. Part of the well-being report is about supporting the transition of older lawyers. And this is certainly something you see too, right, Tim?
It is. As I look at this list, each of those things is something that we have dealt with more than once in the context of a lawyer who's the subject of a complaint. And yes, the aging out of the boomer population, as they say, as they move toward retirement age, and some who aren't ready to retire, but keep practicing when perhaps they shouldn't be because of Alzheimer's, which they may not always recognize. And then those around them, be it colleagues in the workplace, be it support staff in the workplace, other lawyers, judges, are all trying to figure out how do we assist this person and how do we assist the clients of this person. And these are all things that can contribute to problems which will unfortunately land you in front of our office.
And there are quite a number of lawyers who have retired from practice with support of others and don't get there. But then there are those who, because it's the nature of some of the cognitive impairment illnesses, it's almost like your brain says, I don't have a problem. You think you're okay, but you're less and less so. And sometimes the family or their colleagues will say, there's nothing else that can be done other than to take their license, because otherwise they're going to keep practicing. And so you get put in this position of the involuntary retirement, and yet that is what has to be done to protect the public. But if we can do something before that has to happen, that's going to be a better answer.
Absolutely.
Any other thoughts about any of these mental health issues? Just
how they can affect, as you were saying, without people necessarily even realizing it. Grief can be a tremendous consumer of emotional and physical resources. And even in the grieving process, it can have an effect on our ability to do our best work, to do our best thinking. And if it's unresolved, as you know, it can be for people, that's something that we've seen cause problems and get people to the place where there's a complaint filed against them. So all gets back to what you were talking about earlier, the totality of well-being and the interconnectedness of all 6 of those factors.
Yeah, absolutely. And I think that with a lot of these, you don't see it, but others do. And I'll give you an example. We received a call from a judge about a lawyer. It's like, this is a really good lawyer, and they have made these mistakes in this matter, and I don't know what's going on. Well, we reached out to the lawyer, who happened to be someone I knew, and I found out that that lawyer had lost 2 parents and another close family member in the course of 6 months. And they were just kind of a zombie. And they said, I thought I was okay. And they went back later and thanked the judge for letting them know that they needed to get some help. Now, by the way, we didn't say who the judge was, and we didn't say that there was a concern. We just said, hey, how are you doing? And that's kind of the way we work. So let's talk a little bit about, like, if you are working with or for a lawyer who might have issues, it's very tempting to cover up for them. And it's important to recognize, especially if it's a newer lawyer, and I know a lot of people who watch this program are judicial clerks and you're going to be entering your careers. If you don't know how to do something and the lawyer isn't present mentally or physically, don't do it, because you can be the one who gets in trouble. And yet they can be very intimidating, and it can be a very difficult conversation. You can always call for an advisory opinion yourself. You can also call LCL for coaching, but make sure you have resources outside of your job. Any thoughts about that one?
Yeah, as a former big firm associate, I understand the dynamics of certain workplaces, and it's hard to say to your boss or one of your bosses or about one of your bosses, I think the boss is slipping, they're making more mistakes, they're more distracted, whatever it might be, because you're newer, you may not know things that the boss does. Or the boss may have a position of power and you're worried about retaliation. Those are all very understandable concerns. And really what Joan said was, whether it's calling LCL, whether it's calling us for an advisory opinion, or whether it's having resources available to you outside of your workplace, and quite frankly, perhaps even outside the profession, that you can tap into, having those resources and remembering those resources to help you deal with the situation in a way that's best for yourself and for all involved.
Mm-hmm. So, you know, sometimes somebody has a chemical issue, and here's where that 50%, and as a result of that, we have a slide on mitigation in a minute, but sometimes they'll be put on probation with some requirements, right? Absolutely.
The slide here talks about AA, or random urinalysis, in the second bullet point.
And by the way, ASG stands for Abstinence Support Group, so it can be AA or other things.
And so, and that ties into what I was about to say, which is we really do try to find what's going on with the person and craft the probation requirements to the particular situation in a variety of ways. If someone's issues are with handling matters timely and communicating with clients adequately, we will put those kinds of conditions in, but we won't put in trust account books and records requirements conditions. And the same thing with a mental health or substance use disorder. We're going to try to craft the conditions that are most appropriate to this particular person. Some people who have a substance use disorder may, for example, have AA attendance. Others, it may be a therapy attendance because their condition requires them to initiate or continue a one-on-one therapeutic relationship. Some might be both. When it comes to mental health, there may be the same thing about either getting an evaluation, or maybe you've had an evaluation and there's a recommendation for treatment. Some it might be therapy, some it might be medication, some it might be both. So it really is uniquely crafted to the situation to get the person the scaffolding they need to try to help them successfully navigate their situation.
And we've kind of come full circle back to that well-being equals competence, in that when these issues are present, often the way it comes to your attention is a couple of different major parts of the rules, right?
Exactly. You know, the most common type of complaint we get generally, and I think at least intuitively, the most common types of complaint that are tied to the issues we're talking about today are neglect and non-communication or inadequate communication with clients, and the other is non-cooperation. What these really all involve are dilatoriness, and they all can involve something that's stressful. There may be a case where it's the facts or the client or the opposing counsel that causes a tremendous amount of stress, and so we don't want to deal with it, and so we don't handle it, neglect, and or don't communicate with the client, the non-communication. No one really wants to deal with the investigation of a complaint against them. They get an envelope from us, and on the front it has our return address, and it's stamped personal and confidential. It's pretty intimidating for most people, and I get that. And if you take nothing else, and I hope you take a lot out of today, but one of the things I hope you take out of it is please open the envelope. Please see what's in there, and then please deal with it. Even if the underlying complaint was to have no merit, if we're investing a complaint and despite all of our best efforts, we never hear from you, the Supreme Court may well suspend your license. But that's non-cooperation. Need to deal with it. And I can't urge people enough to either, if it's overwhelming to you, reach out to LCL for help in terms of some of the coping, retain counsel. If you can't afford or don't want to get full-blown representation, buy an hour of a lawyer's time to help you through it. Talk to a friend who's a lawyer, something, but deal with it, as hard and as stressful as it may be.
We have sat with people as they've opened that mail, and we're always glad to do that. The thing is, for these particular violations, you know, there will be clients who are unreasonable, or who tend to complain about things in all parts of their lives. Those aren't going to be the ones that show up as actually opening a file. And so by the time the lawyer is like serious enough to open an investigation and pursue it, that is, in my view, probably not a very healthy lawyer. And so to me, these are cases that, yes, there's always a mental health issue, or often a mental health issue, let's say that. And you know, when we're dealing with anxiety, there's an article that talks about it as an ethical sinkhole. We act rashly and in our own self-interest. And that can be anxiety brought on by by mental health issues. When we look at behavioral disorders, that's kind of a broad term on the legal system. Well, it used to be, you know, a crime, a moral weakness. It's not anymore. But there's a number of ways in which this can show up in the regulatory system. And I think we already talked about declining or withdrawing, but there's a comment about preparing for disability. Is it that in the diligence rule as well, Tim?
Yes, that.
But it only talks about solos, and we all should.
Yes, and whether it's disability or whatever transition it might be, whether it's disability, whether it's passing, death, whatever it might be, having a plan. And there's the comment on the screen now. To prevent neglect of matters, here it's in a sole practitioner's death or disability, having a succession plan. Who's going to review your files? Who's going to determine what needs to be done and help make sure these clients are taken care of? I think in many workplaces with multiple lawyers, it's implied that, you know, the workplace will take care of it, and it's the sole practitioner who doesn't have that built-in network in the office. But it is important, whether you're a sole practitioner or not, to be thinking about what happens in the event you are suddenly unable to practice. And the comment talks about the practitioner's death or disability, but you have a child who becomes seriously suddenly ill and you want to take a month off and you have the ability to do so. What is your plan? It's thinking about those kinds of contingencies, which heaven forbid might happen, to protect the client's interest.
And that can also be if the lawyer takes time off. Or it can be, what can a lawyer do in terms of succession planning if they say, you know what, I don't like doing this anymore. I want to do something else. And instead of walking away and forever not having a chance to come back, what are you going to do to close it down? And there's resources on the OLPR site, and there's resources at LCL. And then we have 8.3, which I put in here not because it necessarily fits, but because I always want to talk about it.
And what we see here is the rule, but what we really want to talk about is the exception. But what the basic rule is that if you know another lawyer has committed a violation, raising a substantial question as to honesty, trustworthiness, fitness, other ways, you shall inform the appropriate professional authority, which in almost all instances will be my office, or if it's a judge, the Board on Judicial Standards. That is the basic rule, but then there's the exception. And this is also part of 8.3. The rule does not require disclosure of information gained by a lawyer like Joan or judge while participating in a lawyer assistance program. In other words, LCL. And so, Joan, I will let you talk a little bit about what the practical effect of that is.
Well, I mean, someone can come to us and say, I've got these issues, it's time to get help, and you don't realize how bad it is, here's how I screwed up. That means we can just help them get help. And sometimes it will mean we can also help them find counsel. We don't provide pro bono services or low bono services, and I always think people should have malpractice insurance because it pays for your defense. But it is, you know, it's something where there's a number of people who can help you through this. Lawyers will call us and say, if I call you about someone I'm concerned about, do I still have to report them? And it's like, yeah, you can't report to LCL as opposed to a mandatory duty to report. But it does allow our volunteers who are active with us, as well as our lawyer staff, to have that out.
Yeah, and what it really means is you can contact LCL, whether or not there's been a complaint filed with our office, whether or not you're under investigation. You can go to LCL and say, here's what I'm dealing with. And that might include telling the volunteer from LCL, and here's where I've made mistakes, or here's where I think I'm in trouble. They're not obligated when working in their capacity through LCL to report that to us. You can go and be fully candid and get the help that you need from or through the resources that LCL can steer you to.
So we've been dancing around mitigation this entire program, and here is the case.
We will stop dancing. The music has stopped. In 1982 is when the Supreme Court first recognized that alcohol, in current terminology, substance use disorder, can mitigate the sanction. You commit misconduct. It doesn't mean the violation is no violation. It does not mean that no discipline would be imposed. But what it does is it says, look, if alcoholism caused misconduct and the lawyer's been in treatment and in recovery, that the sanction to be imposed doesn't need to be as great, because we recognize part of what was going on here was in fact this illness. And the factors to establish that kind of claim are laid out here in the slide. And as I said, the court recognized that in 1982, and then the following year in 1983, the court expanded that to mental health issues generally, not just alcohol, but any sort of mental health issue. Again, severe psychological problem which caused the misconduct. And the rationale is, if you have a severe psychological problem or a severe substance use disorder that's caused the misconduct, the protection of the public purpose of lawyer discipline is in part served by this recognition, and maybe as great a discipline is not required, because there's a recognition that the conduct may not be purely a factor of bad motive or whatever it might be.
And what I thought was interesting about these cases is that in Mr. Johnson's case, mitigation was found. In Mr. Weyrick's case, it was not, even though in reading the facts for me, I didn't quite know why. But I'm not in the court. It's the causal connection that's very hard to prove. And here are two cases where individuals were disbarred. One was a mental health issue, one was a substance use disorder. And they did commit misconduct, but it was not found, the causal connection between the mental health and the conduct was not found to be there. And so sometimes lawyers are like, I'm not going to talk about this, because then for the rest of my life, I will be known as the person with this issue. And there's a case from a few years ago called In re Clark, in which there was a comment where the medical record was sealed. And I think that comment where, you know what, the court said, we have seen enough information to show that there is a health issue, and we accept it. And it doesn't mean that the medical record has to be made public. And I think that is the kind of thing that, as much as anything, is going to contribute to well-being, where it isn't something where it becomes everybody's business that you have a medical issue, because that is what this is. And your office has been moving in that direction of showing less as well. So if someone does commit misconduct, in addition to mitigation, there's some other options too, right?
There's disability inactive status, where someone has a condition which prevents them from either representing themselves or representing clients competently. They can be transferred to disability inactive status. Sometimes people agree to that. That oftentimes is the case. The disciplinary matter is stayed. Upon a request for reinstatement, both the disciplinary matter and the condition or conditions which led to the transfer to disability inactive status will have to be dealt with to see if in fact the lawyer is no longer suffering from the condition to such an extent that they are disabled. And I've had cases of this sort where one or more complaints come in, and as we get into it, we recognize there may well have been misconduct here, yes, but there's mitigation, but then this person is suffering even more, and to the point where they're not able to deal with representing themselves, and they will be transferred over. We talked earlier about probationary conditions as it relates to discipline cases. in probation, some of our resolutions are private. They're non-public. They're not the ones that show up out there.
So, Tim, what you're saying is that if somebody has issues and they get some help, that it isn't like they have to deal with it all at once, because if you are dealing with a challenge, and it could be a sick family member too, or you haven't taken care of things, or it could be you, and there's ways to say, I will come back to this, but I need to step out for now.
Yeah.
That can be an option.
Yeah, some people do need to just step away for a bit.
Mm-hmm. And then they're going to come back and be able to practice again if they choose to.
Absolutely.
Okay. So we've got a little bit here on clients, because this is something else that can cause stress for lawyers. And we are close to out of time, but I think it would be really good to touch on some of these, because if we're talking about the client who might be suicidal, for example, the rules provide an out, don't they?
They do, and we touched on this earlier. When a client's ability or capacity to make adequately considered decisions in connection with a representation is diminished for whatever reason listed, we try to maintain a normal client-lawyer relationship. Now, obviously, what that is, it will depend on the client and the context. But then, when we have a client who is at risk of substantial physical, financial, or some type of harm, when they're with diminished capacity, you can take reasonable protective action, including consulting people who can help, depending on the situation. That may be a family member, that might be a social worker, that might be a medical provider. In some instances, it might be a 911 call if someone's in imminent danger of hurting themselves or others. You can take steps to protect your client, and I would say anytime a client is suicidal, by definition, they have diminished capacity.
Mm-hmm. I think that's a really good point to make, that one, it definitely follows the other, and that you can do anything you need to. And you don't spill everything, right?
Not everything. You can reveal what's reasonably necessary to get the client the help they need. It doesn't mean you have carte blanche to say every negative thing you know or surmise about the client, but if there's something that is confidential that you need to disclose to get the client the help they need, you can do so. You are protected under the rules.
And that includes calling for someone to do a wellness check.
Absolutely.
If you are concerned about whether that person is safe. And then this is the confidentiality rule.
Right, and the general rule in A, keep client confidences confidential. The exception in B3, impliedly authorized to carry out the representation, and that ties into what we just looked at. Saving your client's life is impliedly authorized as part of the representation.
It's kind of a circle. It just takes you back there. This is the communication rule that can tie into diminished capacity.
Absolutely. Ordinarily, we treat our clients as fully competent adults, but recognizing there are situations when we may have to act a little differently. When the child is a minor, the younger the age, the more so, or has some sort of diminished capacity, what we tell the client, not that we can lie, but what we tell the client may be affected.
And this also ties back into whether you can decline or withdraw, right? Because if you have a client with diminished capacity, if you're concerned about that client being suicidal, just saying, I'm walking away from this. It may be that sometimes you have a little bit more that you can or should do under that rule.
Absolutely. You can treat the client the way that you need to in that situation.
Mm-hmm. Okay. I also like this rule, which sort of doesn't quite tie in with clients, except that the lawyer, it might be the way the lawyer deals with a client. But this is something where, we think about, okay, I'm a lawyer and people come to me and I give them legal advice and I do all of these things. But if we think of ourselves as also having supervisory responsibility over somebody else, if you have a lawyer who is going to be, who you think might have some impairment issues, can you just hope it'll get better if you have supervisory responsibility? You
can hope it gets better, but you can't end there. You have to do more than that. You need to do what you need to do to help that lawyer get to the point where they need to be to represent clients, or perhaps help that lawyer step away for a little bit from representation, if in fact to the point where they can't do that. Part of being a supervisor isn't just making sure all the briefs don't have typos. It's a lot more than that. And part of that is to take remedial action when you see something going on to mitigate the consequences.
Mm-hmm. And this is where sometimes when an organization comes to LCL and they're concerned about a lawyer, and they'll say, well, maybe we'll just, thanks for the conversation, we'll hope it gets better. And I said, do that, but I suggest you also take a look at 5.1. I can't tell you what it says, but I suggest you read it closely. And then maybe a day later, a week later, an hour later, we'll get a call back. It's like, yeah, I think we want to go a little further here, because you can't just hope it'll get better, and if you know that there might be some issues. I actually started talking about this one a minute ago, and then I jumped back to 5.1, but this is my favorite rule, because it allows us to be more than technicians, and it allows us to find well-being in that we get to say, well, here's what I think, not just here's what the rules say. And so this can be a way that we can have greater connections with our clients, which give us more well-being. What's your perspective on the lawyer's advisor rule, Tim?
Similar to you, Joan. I mean, advising clients is more than just the technical areas of the law. It can be, as is underlined here, it can be inadequate. And I certainly have examples from my prior life in private practice and in my current practice where it's not just technical legal advice that actually gives us the optimal solution. We need to take into consideration other things, including, at times, issues of well-being.
Mm-hmm. And I think this is also an opportunity for a lawyer to think about, okay, how does this client find closure? And this client has already come to a professional, and so they're ready to take professional advice. So let's just say it's a personal injury case, and you have a financially unsophisticated client who is about to get a big award. Wouldn't a reasonable thing for that lawyer to do to say, I would recommend that you talk to a financial advisor who's going to help this settlement or award do what it is intended to do? That is appropriate advice. So if you have a client who is impacted mentally, and situational depression is very common in legal cases, by the case, it's okay to say, you know, a lot of my clients find that they do much better if they're also talking to a counselor. And because another professional has said that that's okay, that client may very well do that. And then you don't have to be their counselor, and you can feel like you helped to provide a greater closure to that client, thus resulting in greater well-being for you.
Yep, you've given that client permission, and it helps both of you.
Right. So, and that takes us back to this comment to the rule on diligence, which I think is pretty good. I'm going to say a couple more things about LCL, but first you're going to talk about the advisory opinion service, right, Tim?
I am. Don't be bashful. We get 2,000 calls or so a year. If you have an ethics dilemma, professional responsibility dilemma under the rules that you're facing, what do I do going forward? You can call us and we will give you our best off-the-cuff advice, and we usually can answer your question or point you in the right direction. We won't answer questions about past conduct. We won't answer questions about someone else's conduct. The other lawyer did something wrong. We won't answer those, but we generally can be a help, and as I said, we get about 2,000 calls of these, 2,000 of these calls a year. So please feel free, and it is confidential. It's between you and us.
I think it's a great service, and I think it's a great stress reliever. In terms of LCL, I talked about free counseling earlier, and we're confidential. An organization can call us for guidance, and an individual can call us for help. We have a partnership with this organization for free counseling. This is their website as well, and they also have some resources that you can access. You can also call them directly to set up an appointment if you don't want to go through LCL. The key is to say, I was referred by lawyers concerned for lawyers. And here's LCL's contact information. So any final words, Tim?
It's always a pleasure to present with you, Joan. And I have 3 quick bullet points that I hope people take away. The importance of your own well-being, paying attention to the well-being of people around you, And if you think you or someone around you needs some help or some support, be sure to reach out and get it. It's good for you, it's good for them, and it's good from a professional responsibility perspective.
Thanks, Tim. If you think it'll get better on its own, it probably won't. Call us. Thanks for joining us today.
Thanks, everyone.